So today we're going to spend a little bit more time on the mechanisms for judicial control, additional mechanisms, and we'll talk about the standards for judicial deference. As we learned before, the judiciary and the judicial branch tends to defer to the administrative branch and provide discretion when it comes to matters of administrative law and policy. So we're going to talk about what the standards are for that deference. We're going to talk about the standards of review, or how it is that the courts look at cases related to administrative actions. And then we're going to talk about statutory construction a bit, and finally the doctrine of standing. So why do courts defer to administrators? You'll remember from last time that courts generally acknowledge that the administrative branch has a certain level of expertise that can't be matched by the courts. While judges need to know the law, they rarely get to focus on a single subject matter and instead need to apply the law to a variety of different subjects that might come before them. On the other hand, the administrative branch typically can focus on a single subject matter or area of policy and develop a deeper expertise in that area. Courts also understand and defer to the fact that the administrative branch needs a certain amount of flexibility in order to apply the law and administer policy. The laws cannot encompass or consider every potential issue or application of various policies, so the law naturally leaves some flexibility for administrative branch to carry it out. The courts understand this and defer to the administrative branch in that regard. Finally, courts also understand that when it comes to the management of public resources and making decisions about what policies to apply and what individuals to serve or not to serve, that the administrative branch is in the best position to do that. And the judicial branch is not equipped to step in and make decisions about what policies to apply and what programs to operate. Finally, courts also understand that the administrative branch has a certain level of accountability to the public that the judicial branch cannot have. For example, and especially at the federal level, the administrators, the cabinet level individuals and people who run agencies are accountable to the public because they answer to an elected official, the President of the United States. Judges who are in the federal system appointed for life don't have that kind of accountability. So the judges, at least at the federal court level and following along in that same philosophy, the state judges apply this as well, will defer to an administrative branch official's decision about a particular issue, understanding that that official is more accountable to the public and in a better position to speak to and apply what the public wants in a particular area. There's also the basic concept of separation of powers, and the judicial branch will defer to the administrative branch because of that deep philosophy within the Constitution. So there are different theories as to why there's this deference, but it is uniformly accepted that courts must defer to the administrative branch, but only to a point. So how do the courts defer to administrators? There are different ways that the courts have looked at this over time. In general, separation of powers has been an overriding principle in our Constitution since the earliest days, but it wasn't until 1984 that the Supreme Court of the United States first articulated an actual standard for the judiciary to apply. So this standard, or the rule of judicial deference, sets the way that the courts are to follow when looking at agency actions. That standard was set in Chevron USA versus Natural Resources Defense Council. It was a case decided in 1984 by the U.S. Supreme Court. It stemmed from issues related to the Clean Air Act. The Clean Air Act required the EPA, the Environmental Protection Agency, to establish a permit program. That permit program was to regulate air pollution and to require pollutants to limit or eliminate pollution under certain circumstances. Among other things, the EPA was empowered to issue permits for new or modified major stationary sources of air pollution. So the Chevron case dealt with what is the stationary source of air pollution. How should that term be defined? In the Carter administration, the EPA interpreted and enforced this regulation to be a per source or per machine, per smokestack, per pollutant standard. Therefore, on a large factory with dozens of smokestacks, for example, each and every smokestack had to meet the air pollutant emission standard that was set. When the Reagan administration came into office, they interpreted the same regulation differently. What they did was awarded permits and enforced based on an entire plant. So rather than making sure that each individual machine met air pollutant standards, they looked at the total emissions from an entire plant. This was, of course, a more liberal standard. It was easier for manufacturers to be able to offset the pollutants from one machine with a lower polluting machine somewhere else. So the overall emissions of the plant still met the standard, but were probably higher than what they had been under the Carter administration's interpretation and enforcement standards. What SCOTUS held was they ruled in favor of the Reagan administration's discretion. They held that the plant-wide definition of a stationary source was permissible and was reasonable. In reaching its conclusion, the Supreme Court of the U.S. first came out with a definitive standard for how courts should look at agency decisions. What this is, or the standard of review, is SCOTUS's edict to the lower courts that they should give deference to agency decisions by applying a certain standard. What the Supreme Court held was that agencies have to defer to agency interpretation to respect the legislature's decision. That's to give the agencies discretion and to acknowledge that they have expertise. The test that Chevron sets out is for the courts to look at two different things. First, did the legislature speak to the precise question at issue? Did the legislature define what is a stationary source? If it did, that's the end of the matter. The agency should apply exactly what Congress or the legislature gave them, and no additional analysis is needed by the judiciary. But if the statute is silent or if it's ambiguous, the courts give deference to the agency's reasonable interpretation. So the Chevron court held that deference should be granted, but only if the legislature intended to give agency discretion. In the Chevron case, and in the statute at issue there, the court found that Congress didn't actually make any specific expression of intent in the statute. They didn't say that the EPA would have exclusive authority to determine what constituted a stationary source. But the Chevron court also found that Congress intended the EPA to have broad discretion to set various standards under the Clean Air Act. They found that Congress also intended to allow for reasonable economic growth. And the court was persuaded by the arguments set forth by EPA that were a reasonable explanation, the court found, that its interpretation of the Clean Air Act served Congress's objectives. So at the end of the day, the Chevron court ruled in favor of the EPA. So what is a reasonable interpretation? As you might imagine, there could be numerous interpretations of a particular law that could apply in different situations. For example, when looking at the Clean Air Act and what constitutes a quote-unquote stationary source, it is reasonable that the administration determined that a stationary source is a particular piece of equipment or a particular smokestack. It is also reasonable to interpret that same phrase as meaning the entirety of a plant. It could be reasonable to interpret that as one building within a plant that has numerous buildings to it. All of those interpretations are reasonable, and what the Chevron deference says is that the courts must accept the agency's interpretation, and they must accept it even if the court or the judges think that there is a more reasonable interpretation, or even if it is what the judiciary would not have done in that circumstance. This requires courts to put aside their judgment in favor of the administrative branch. And as you might guess, there have been legal scholars and judges and justices even who have criticized that and felt that the Chevron standard gives too much deference to administrators and takes too much authority out of the hands of the courts. In fact, Justices Thomas, Gorsuch, and Kavanaugh have all hinted in various opinions that this violates the separation of powers. Justice Thomas has been overt about it and has called for Chevron to be revisited. So at some point, the pendulum may swing back and the court may take some of this discretion away from the administrative branch. But for now, Chevron is the law of the land and is largely what is applied by the courts when looking at various issues that deal with administrative discretion. So let's look at a few examples of what constitutes a reasonable interpretation. In one recent case, the Supreme Court looked at the Social Security laws and looked at the definition of a child, which is longer than this, but for our purposes, the child or legally adopted child of an individual. Social Security law also allows the Social Security Administration Commissioner to apply the intestacy law of the insured individual state. What that means is that the commissioner was permitted to look at the laws of a particular state regarding intestacy or inheritance from where the insured, the person covered under Social Security, was living at the time of their death. Florida law contained a provision that marriage ends when one spouse dies. So in this situation that reached the U.S. Supreme Court, Karen and Robert Cappato married in Florida in 1999. Unfortunately, Robert had esophageal cancer and was not doing very well. They froze his sperm, and Robert specifically noted that he wanted his wife to be able to use that even after his death. Robert did die in 2002. 9 months later, Karen was inseminated with his sperm through in vitro fertilization, and 9 months after that, gave birth to twins. She applied for Social Security benefits for the twins and was denied. So the issue that reached the United States Supreme Court in this case was whether or not the children conceived through in vitro fertilization and born 18 months after their father's death were entitled to Social Security survivors benefits. The Social Security Administration argued that because the children could not inherit under Florida law, they were not entitled to Social Security benefits. The Social Security Administration also noted that as a policy perspective, the Social Security laws and funds were meant to take care of individuals who had contributed to the system throughout their lifetime, and that extending benefits to those who weren't alive during the decedent's lifetime undermined the philosophy and the reason for the program. Cappato argued that the Social Security Administrator didn't need to look any further to Florida law, but that should have just stopped with the definition of a child. In this case, the twins were biological children of the insured. There was no question of that. And Cappato argued that the Social Security Administrator made an error in looking further. The Supreme Court of the United States applied Chevron. They deferred to the Social Security Administrator's interpretation and ruled for the Social Security Administration. The court held that Congress granted the Social Security Administrator the authority to interpret the law. The administrator did that in promulgating rules, and that the administrator's interpretation was, quote, at least, end quote, reasonable. The court acknowledged the circumstances behind the case, but held that it was important for it to apply Chevron and follow the letter of the law. What the court said in a unanimous opinion was, tragic circumstances, Robert Capato's death before he and his wife could raise a family, gave rise to this case. But the law Congress enacted calls for resolution of Karen Capato's application for child's insurance benefits by reference to state intestacy laws. We cannot replace that reference by creating a uniform federal rule that the statute's text scarcely supports, end quote. So courts do not always follow what the agencies prescribe. Agency deference stops at a point. Many cases have been decided on what constitutes arbitrary and capricious action by an agency. And if the courts find that the agency was arbitrary or capricious in what its decision was or what its program carried through, the courts will not give deference and will instead apply a different interpretation, or more likely remand the case back to the agency to rethink what it did and apply a different standard. So throughout the case law, we'll see various points where courts have found something to be arbitrary and capricious. And these are good places for administrators to just keep in the back of their minds and watch for as you are implementing a program or taking a particular action. Just knowing that if your activities go too far beyond what the legislative branch set out for you, you could be found to be arbitrary and capricious. So these kind of cases arise in a couple of different settings. Oftentimes, the courts will find that an agency relied on something which the legislative branch had not intended the agency to consider. Other times, the judicial branch will find that the agency simply failed to consider something which was in the legislation or something which was important to whatever the problem is at hand. Other times, agencies will offer an explanation for its decision that just does not comply with the evidence that was before the agency, and the court will find that the agency was arbitrary and capricious because it viewed evidence in a way that was counter to what was actually before it. And sometimes, on rare occasions, but sometimes there are situations where a court will find that what the agency did was so implausible that it just simply could not be reasonable. It just simply was not something that could be ascribed to a difference in view of what is or isn't reasonable. And the courts will strike down an action as arbitrary and capricious in that circumstance and send it back to the agency for additional reconsideration. So let's talk about an example of arbitrary capricious. And as we go through this, put yourself in the administrator's role and try to think of how you would react, especially knowing, as we're talking through this, the way that the court ruled. And try to consider what other types of approaches you might have taken as an administrator to avoid or better assure whatever the court outcome was. So here's our first example. It comes from the NHTSA, the National Highway Traffic Safety Administration, which is a federal board that is charged with Congress to issue safety standards for motor vehicles. What they are told, or what Congress tells the NHTSA to do, is to make standards that are practicable, meet the needs for the motor vehicle safety, and making sure that those standards are stated in clear and objective terms. Congress also instructed NHTSA that when it's adopting regulations, that administration needs to consider the relevant available data about motor vehicle safety. It needs to make sure that its standard is reasonable, practicable, and appropriate, not only for the mission that it's carrying out, but also for the type of vehicle that it is trying to regulate. And finally, Congress advises or instructs the NHTSA that when it issues regulations, the administrative body has to make sure that it considers the extent to which its regulations will actually contribute to carrying out or carrying forth its mission or the purpose of the regulation. So in 1977, the NHTSA required all cars to have a passive restraint system. Passive restraint systems are automatic seatbelts or airbags, things that automatically protect a driver or passengers without the need for those individuals to do something active. So a passive restraint automatically kicks in. As you'll see from the picture below, and some of you may remember cars like this, there was at one point in the 80s, no longer, but there was this system where the seat belt, as you see there, would swing down automatically. The driver could get into the seat, and then when the door closed, the seat belt would automatically slide up and along the window frame and over the driver's shoulder. In 1982, though, the NHTSA rescinded the automatic seatbelt standards. Basically, what they used as their reasoning for doing that was that they couldn't demonstrate that the use of automatic seatbelts had a significant safety benefit, or that mandating these automatic seatbelts actually led to increased usage. What they found was that people really hated them. Consumers hated them. My first car had this. I remember I hated them. And as a result, people disabled them. They didn't use them. They put them over the back of their shoulder, whatever the case might be. But people just largely weren't using this particular type of seatbelt. So seatbelt usage was very low, and not surprisingly, it was difficult to prove that there was any significant increased safety benefit as a result. These types of seatbelts were also very costly to install, so automobile manufacturers were not particularly thrilled with them either. So for those reasons, the NHTSA rescinded its rule requiring automatic seatbelt standards. The insurance agencies challenged that rescission. Insurance agencies argued that the NHTSA didn't look far enough and didn't use reasonable methods to assess whether or not that rescission was necessary. What the insurance companies argued was that the NHTSA didn't present an adequate basis or an adequate explanation for eliminating a requirement for seatbelts. Insurance companies argued that the NHTSA should have considered the possibility of manufacturers installing a non-detachable belt, one that was still passive, but that was not detachable like the one that you saw in the picture before, and it is like the one that we are familiar with today. Finally, insurance companies also considered that the NHTSA failed to consider other methods for requiring compliance, whether or not there were other things that the NHTSA could have done to still require a passive seatbelt system, but to encourage compliance through some other way. So in this case, the Supreme Court of the United States ruled against the administrative agency and for the insurance companies. The court found that the rescission of the passive restraint rule in its entirety was arbitrary and capricious, and criticized the agency for failing to present an adequate basis for its action. They felt that the reasons that the NHTSA gave to the court for rescinding the rule were simply not adequate or compelling enough. They also suggested that the agency maybe should have considered the impact of mandatory airbag use, or taken into account the difference between detachable seatbelts and manual seatbelts. In other words, the court felt that the NHTSA should have thought about other types of safety restraint standards that might have been impactful here and had less of an impact on the negative impact on the public. They also believed that the NHTSA should have considered at least amending the standard and tried to amend the standard or come up with other ways to require safety features without simply removing the standard altogether. So what the court did was remanded or returned the matter to the NHTSA for further consideration. And what that means is that the court, and this often happens with these types of cases, is the court will find that the rule was arbitrary and capricious, but rather than the court deciding the matter for the agency or trying to insert the court's judgment for that of the agency, it will return or remand the matter to the administrative agency experts for their further consideration. Now, it is possible that after a remand, the agency will look at the things that the court suggested might have been beneficial and returned back with the exact same rule. In other cases, after having looked at various different things, the agency might tweak its rule or do something different altogether. And in either case, the court will defer to the agency's judgment on that. So what happens is the court will remand, the agency will review and revise or not after additional review. And then if individuals or, like in this case, insurance agencies and industry are still concerned about the impact of the rule, they can take the case back up through the court system and have it reviewed again as potentially still being arbitrary and capricious. Now, in this particular case, you can probably guess what the NHTSA did from your own experience today driving cars. As you know, automatic airbags are now very standard in many cars, and that's as a result of the NHTSA's reconsideration of safety rules and the platform of this case. You also know that those automatic sliding seat belts are no longer used. Now we have the type that are permanently affixed behind our shoulders in the car. And perhaps the most interesting thing that the NHTSA did, and the most impactful thing that it did after taking this case back on remand and thinking through what else it could do to increase safety standards, was an advertising campaign. The NHTSA started the campaign on a national level of educating the public and educating police. And you've probably all seen the billboards that say "click it" or "ticket" on them. That is as a result of this case. And the NHTSA is taking this matter back under consideration and finding alternative methods that weren't arbitrary and capricious, but still carried out the mission of the agency. Let's look at another example of arbitrary and capricious and how the courts have applied it. In this case, which came from a district court in Ohio, the Ohio General Assembly had passed a law that made the sale of wildlife a crime. And what the General Assembly had done was set various standards. The sale of over $1,000 of wildlife was a felony. Amounts under $1,000 were misdemeanors. The General Assembly in its statute also authorized ODNR, or the Ohio Department of Natural Resources, to establish the value of the wildlife. ODNR set a scoring system. They had specific dollar amounts for certain types of identified animals, and then they had another category that was for any other kind of wildlife. All other wildlife was set at $20 per animal. As to most animals, deer, bear, fox, for example, ODNR had a scoring system that they had established that was based on recreational, aesthetic, educational, economic purposes, and most importantly, the designation of the animal, whether it was endangered or not. Violations were punishable, as I said, based depending on the amount of the wildlife that was taken, as calculated by ODNR, as either a felony or a misdemeanor. Ronald Gasparak was selling yellow perch. You see a picture there of yellow perch. They're relatively small game fish, largely found in Lake Erie, was selling those on Craigslist. And an undercover wildlife officer found this on Craigslist and purchased from Gasparak on 3 separate occasions. Now, yellow perch wasn't one of the specified animals that had an identified dollar amount per animal or per pound, but yellow perch fell then under that catch-all miscellaneous category of $20 per fish. Gasparak had sold on 3 separate occasions, and he had sold multiple numbers of fish. So the total value, each of the 3 occasions was over $1,000, and total was $6,120. He was convicted of 3 counts of illegal sale of wildlife valued at over $1,000. So these were each 5th-degree felonies. Gasparak was convicted of the 3 felonious counts. He was placed on probation, and he was ordered to pay restitution to ODNR at $6,120. Gasparak moved to dismiss the case against him. He argued that $20 per fish was arbitrary and capricious, and that had ODNR set more reasonable standards that were based on a per pound valuation, for example, he would not have been charged with a felony. He claimed that $20 per fish, when talking about an animal as small as a yellow perch, was well above market value and therefore was simply arbitrary and should not serve as the basis of a felony against him. ODNR countered and argued back that when it applied valuation on all wildlife, it looked at a number of factors other than or including market value and the actual cost of buying an animal for consumption. ODNR argued that among its valuation and reasons for setting various amounts per animal and then having the catch-all exception at $20 per animal was for valuation of all wildlife, and that was based on a sport and an economic value to legitimate hunters and legitimate naturalists, or in this case, people who were interested in fishing the Great Lakes. The court found that compelling and ruled for ODNR. It found that ODNR was reasonable in setting its valuation and that it wasn't arbitrary or capricious. It also cited the legitimate basis for a deterrent effect. The reason for ODNR to set forth a rule to deter people from hunting and taking animals illegally. And the court found that the rules were clear and that Gasparak certainly was on notice that his taking of this wildlife, the yellow perch, would have potentially led him to a felony having that valuation at $20 per fish. So Gasparak lost his case and the court ruled for ODNR. Another place where courts will not give deference to agencies deals with adjudications. Now, adjudications are like mini trials. They're areas where an administrative body can have a hearing and take evidence and make a decision for or against a person who's applied for a permit or has been found to violate something. It's more of a court-like process where witnesses can be heard, expert testimony can be given. There can be formal adjudications, which are very formal, with witnesses actually being sworn in and documents being presented, or there's an informal adjudicatory process, which can sometimes take place where there's a one particular public official or employee who is looking at a permit and making a denial or granting a benefit. In these adjudication hearings, what the agency is to do is to apply the particular set of facts before them to the specific issue. And in most cases, the courts will give deference to the agencies as they go through that adjudicatory process. But in some cases, if the agency acts in an arbitrary and capricious manner, of course, the court will not give that deference. Let's talk about an example of a case. This arises out of the Zoning Commission in Streetsboro, Ohio. Streetsboro is a city in northeastern Ohio, largely residential area. There was a company active in Streetsboro and across the state, but particularly in Streetsboro, called Shelley Materials. Shelley Materials was a mining company that largely mined for gravel and sand. Shelley Materials had a contract to mine under a local horse breeding farm, which was within the Streetsboro city limits. Shelley applied for a zoning change to allow it to mine. The horse farm was zoned in a particular manner that made the ability to mine okay, but it required that a zoning change be obtained first. The city began zoning hearings, so the zoning commission began to hear evidence. This was a formal adjudicatory process from Shelley Materials and began the process of considering whether or not it would grant the rezoning to allow Shelley to mine under the horse farm. Once the hearing on the rezoning petition began, there was a public outcry. Members of the Streetsboro community petitioned the Streetsboro City Council and went to the zoning committee hearings to protest this proposed gravel pit. The laws were eventually changed, and currently in Streetsboro, the zoning or the rezoning that Shelley Materials had tried to get in this case would not have been allowed. But at the time, the zoning laws did allow Shelley to apply and obtain a rezoning if Shelley was successful in proving several different things about its project. As you can see from the map above, the yellow section is the proposed gravel pit. And to give you some idea of why the citizens of Streetsboro were concerned about this, you'll see that to the north is a current gravel pit. Shelley Materials had at least 3 other gravel pits in the area, including the existing one that you see to the north there, which was approved through a zoning change, just as this one was. The proposed pit lies just to the south. But otherwise, surrounding the gravel pit are residential areas. You'll see towards the south and to the north. You'll see a new high school just immediately to the north. So there was a good bit of residential community surrounding what had been a horse breeding, or what still was a horse breeding farm, and what was proposed to become a mining operation. So hearings on the rezonings continued. Shelley gave expert testimony, provided evidence, provided a good bit of information to the zoning commission to establish that its proposed project was consistent with the reasons for the rezoning. The city heard testimony from neighbors. It heard city planning officials talk about the way that the value of the property might be diminished. The city did not put on a great deal of evidence in this case, but largely heard from neighbors who were very upset about this horse farm being turned into a mining operation. The zoning commission denied the rezoning change. Shelley Materials appealed to the Court of Common Pleas, and as often happens in these cases, a magistrate was assigned to hear the case in the first instance. In the court system and at the trial level, so the Court of Common Pleas is the trial level, there are often magistrates who will hear an appeal or hear a case that is presented to the court in the first instance. This happens in civil cases and administrative appeals where magistrates who are employees of the Court of Common Pleas, lawyers, will listen to the evidence and take testimony and then write a recommendation to the judge. That's what happened here. So the magistrate heard the case and found that Shelley met its burden on all of the factors that it needed to qualify for zoning. The magistrate also found that the city really didn't do anything to refute that burden and didn't provide much evidence about why the rezoning shouldn't be permitted. So the magistrate recommended in her decision in favor of Shelley. The trial court agreed with the magistrate and issued a final ruling, found that the city was arbitrary and capricious in denying the rezoning. The city appealed and won on a 2-to-1 vote in the Court of Appeals. The Court of Appeals ruled that the lower court placed too high a burden on the city, that the magistrate and the trial court should have provided more deference to the city than it did. So the Court of Appeals reversed, Shelley appealed, and the Ohio Supreme Court took the case. So the Ohio Supreme Court heard argument in March of 2019, and the case is currently pending there without a decision. Hopefully we'll get a decision during the course of our semester, and we can talk about this in a little bit more detail. But this case is a good example of how the courts will look at a standard of deference and can come up with different focuses and different burdens on city administrators when they take an adjudicatory action. Hopefully the Supreme Court will issue its ruling soon and may set a new standard for us here in Ohio when these kinds of cases are before the Ohio courts. Another way that the agency might abuse its power or act in an arbitrary, capricious manner, and another example of when the courts will not provide agency deference, is when an agency acts beyond its powers, or ultra vires. What this is the agency acts beyond what the authority is granted to it by the General Assembly or Congress. It is well established in case law that agencies, administrative agencies, can only exercise whatever authority is explicitly granted to them. So unless Congress or the General Assembly grants authority to a particular body or reasonably grants discretion to that particular body to carry something out, the agency cannot take action. So the focus here is, what does the statute say? What can be reasonably inferred from the statute? And did the agency have the power to do what it's arguably being challenged that it didn't have the power to carry out? An example of a case, I guess we'll stick with the horse theme here, comes from the Ohio State Racing Commission. This is an administrative body of appointed officials who largely regulate racing in Ohio. The case arose when a winning horse at a thoroughbred race tested positive for illegal substances. It tested positive for Zantac, same kind of Zantac that you and I can take over the counter for allergies, I believe, but it was an illegal substance when found in this horse. So the thoroughbred horse, which had won its race, was ordered to return the purse, the prize money, and ordered to pay the costs of the hearing before the State Racing Commission. The statute that authorized the Racing Commission to hold these kinds of hearings and make assessments, take purses away from winning horses, was drafted to allow the Racing Commission to impose many different kinds of penalties, but there was nothing in the statute that said that the commission could assess the costs of the hearing against a horse's owner. So the court looked at that and reversed just that portion of the penalty. It found that the Racing Commission acted outside the authority granted to it and therefore reversed that portion of the penalty, but upheld the rest of it. So the owner still had to return the purse, but the owner was not required to pay the costs of the Racing Commission's hearing. Let's look now at another mechanism that the judicial branch uses to provide deference to an administrative agency, and that is statutory interpretation. Statutory interpretation is basically the way that a court will look at the written word that was usually written by the legislative branch, Congress or the General Assembly, and determines how that should be interpreted. In some cases, the courts are looking at an administrative agency's rule and will look at the words of the rule to determine what that interpretation should be, and more importantly, whether the agency's interpretation of the words or phrases in the statute were reasonable. Courts will, as we learned from the Chevron analysis, give deference to the agency's interpretation so long as it is reasonable. And to figure out if an agency's interpretation is reasonable, courts will look at the plain language of the law and look for what the intent was. So courts will find intent behind a rule or a law primarily by looking first at the plain language. If the meaning of the law is clear and decisive, then the courts will not engage in any further interpretation or statutory interpretation. If the administrative branch applied the law according to its plain language, the court will do no more other than uphold it. If the administrative branch did not follow the plain language of the rule or the law before it, then the courts will generally reverse and remand. Courts can also look at other expressions of intent. They can look at legislative history behind the particular passage of the law or rule, and then they'll also apply various types of judicial doctrines to determine what the statute says and how it should be interpreted. There are literally dozens of judicial doctrines that a court can apply. We'll only talk about a few of those that appear most often, but just know that there are a number of different mechanisms that a court could apply to look at language that you as an administrator have drafted in a rule, for example, or that you as an administrator are required to apply as part of your daily job. Words that were written by Congress or by the legislative body. There are several overriding principles that courts will abide by when engaging in statutory construction. First and foremost, as I mentioned, the courts will not engage in construction if the statute is plain. If the words of the Congressional Act are clear, the court will not engage in any type of construction. The courts also rule and generally abide by rules that say that the court should not add words to a statute or delete them from the plain language. So what's written by Congress is what is interpreted. The court also strives to make sure that its interpretations of the law are done in such a way that the law is not unconstitutional, or that the language as interpreted does not lead to a ridiculous or impossible outcome. So there's a certain degree of common sense that's employed when courts are engaging in statutory construction. A few places that the courts will look to guide themselves when trying to determine the plain meaning of or the meaning of a statute. One is within the statutes themselves. Most codes have within them rules of construction that apply to the entirety of the body of law within that particular jurisdiction. Here's a couple of examples from the Ohio Revised Code, which help courts determine the rules that they should apply if there is any need or ambiguity in a statute. One is very much like what we just talked about. Revised Code Section 1.47 says that it's presumed that the entire statute is to be effective and that a just and reasonable result is intended, or all parts of the statute must be given import, and the effect is supposed to be reasonable and not ridiculous or impossible to carry out. Revised Code 1.42 is also a fairly common principle that you'll find in various bodies of law, and that's that everything should be read in context and construed according to regular grammar and common usage. Words and phrases that are technical in nature should be construed according to that technical or particular meaning that they've acquired. And finally, here's one, not finally, there are many of these kinds of rules, but here's another one that you'll generally find in various types of laws, and that is that words of one gender include words of the other gender. Therefore, you will often find statutes that use he or him, but Revised Code 1.43, for example, means that that is intended to apply to any gender. You will also find rules of statutory construction and guidance for how administrative rules should be applied within the administrative rules themselves. For example, the definition section of an administrative rule will often include hints and guidelines for the courts as to how the rule is to be constructed or interpreted. For example, the Code of Federal Regulations has rules related to the Endangered Species Act. Those rules include a definition of the word take. That definition is significantly broader than just hunting or trapping an animal, but it also includes taking its habitat or modifying or degrading its habitat to an extent that the animal is endangered. Homeland Security rules provide definitions for what a lawfully admitted permanent resident means. And you'll see there that the rules talk about that ability of residing permanently in the U.S., which such status has not been changed. So check the definitions section when you're looking for how a statute or rule should be interpreted. And if you are an administrator who's drafting rules, you should also give some thought to what types of definitions you want to include in your rules so that courts that look at it at some later date are able to administer and understand the rules in the way that you meant them to be administered and understood. Another way that courts look at various types of statutes is by the application of certain statutory canons or rules of construction. Some of this, once again, just a reminder, you're not going to have to memorize Latin, but you may well hear this if you're looking at a statute or a rule that contains a list of items. So expressio unius is basically the principle that the inclusion of one thing implies that other things are excluded. So where the law includes a list of specific items, things that aren't listed are not included. For your purposes as an administrator, if you are looking to draft a rule or a statute that includes a regulation applicable to a number of things, just be careful with the way that you list them. For example, there was a statute, maybe still is a statute in Virginia, that prohibited any horse, mule, cattle, hog, sheep, or goat from running upon lands. The question that came before the court was, does that law apply to turkeys? In this case from Virginia in 1938, there were two neighbors who had adjoining farm operations with a fence between them. Lucy Ogg raised a number of different kinds of wildlife, including turkeys. Those turkeys trespassed on her neighbor's Pendleton Tate's land for many years and caused a considerable amount of damage to Tate's crops and fields. Tate eventually filed in the court for injunctive relief, or as you'll remember from our earlier discussions, injunctive relief is a request to the court to stop something from happening or to enjoin Ogg from allowing her turkeys to trespass. At the time, under the Virginia State Code, the section made it unlawful to permit horse, mule, cattle, hog, sheep, or goat to run at large upon lands that were enclosed by a fence, which Tate's lands were enclosed by a fence. So the question that came before the court was, are turkeys covered by the Virginia trespass law? The court looked at cases from other states regarding chickens that had wandered onto other people's grounds. And as you'll recall, that's precedent, but it's not mandatory precedent. It's persuasive precedent coming from other states. The court used those cases to consider the nature and habits of poultry and compared and contrasted those habits to cattle, swine, goats, etc., the type of animals that were regulated under Virginia law. The court held that turkeys were not included. Using the rule of statutory construction, they found that turkeys were poultry and that their nature of being able to fly as well as walk, to be able to roost in trees and fences, was very different from cattle and other types of domestic animal, and found that the Virginia trespass law did not apply to turkeys. Another canon of statutory construction is Justum Generis. This one is very close to expressio unius And you'll find this when statutes are drafted to try to include a catch-all type of categorization. So what this canon says is that where the statutes include a list or a series of descriptive terms, other objects that are similar to those descriptive terms are also intended to be included. So, for example, there was a statute that referred to sheriff's constable, peace officers, state road officers, and then a catch-all phrase, or any other person charged with the duty of enforcement of the criminal laws. A case arose where it became an issue before the court as to whether or not that statute applied to prosecuting attorneys. In the case out of Utah, Heathman versus Giles, there was a law that required plaintiffs to post a bond if they were suing a law enforcement entity or person. Heathman filed a case for wrongful prosecution against a prosecuting attorney. He did not post bond, so his case was dismissed. Heathman then appealed. The court looked at the law and found that prosecuting attorneys and police were all tasked with enforcement of the laws, so they were all similar in that nature. But the court looked further and found that other law enforcement officials mentioned in the statutes were on the front lines. They had direct public contact, they wore badges and carried guns, and were much more within the heat of the moment than prosecuting attorneys were. The court applied the principle of justum generis and held that prosecuting attorneys were not included in the phrase, or any other person charged with the duties of enforcement of the criminal laws in this state. So Heathman was able to reinstate his case against the prosecuting attorney without posting a bond. Let's talk now about another rule of statutory construction called in pari materia. This means that related statutes or acts should be thought of together and should be interpreted as if they were the same act, even though they might be separate statutes or separate provisions, even in different chapters of the code. So let's talk about an example. One example comes to us from federal law, the Hours of Service Act. This act was adopted by Congress, and it was meant to regulate the amount of time that railroad workers could be on duty. This was a safety measure. It basically said that workers could not be on duty for more than 12 hours and then still operate a train the next day. What happened was train workers were actually paid for their time, including overtime, and this was simply a safety measure that would result in fines against the railroad companies if there were violations. It was meant to prohibit fatigued employees from operating, but didn't control their salary or overtime pay. The issue presented to the court came up when situations arose on long cross-country train trips, for example, when it was not possible to get to the next station to shift out a crew. So what would happen is that there were portions of the country where the train would travel for its 8 hours, which was the working day allotted time, and still could not reach the next station. So the train would stop after the allotted travel time had elapsed. The tired crew would disembark, a fresh crew would embark, and then the crew that had disembarked was taken to the nearest station in order to then spend the night, travel back the next day, or travel back that night, whatever the case may be. But the issue arose as to how to count that time between the time when the crew got off the train and was then transported to the next or nearest train station in order to end their day. The HSA actually talks about how to deal with time commuting to and from a train. It calls that deadhead time. Time in the statute itself, time spent traveling from the work site was not counted towards the 12 hours of fatigue. Time spent traveling to the work site did count towards that 12 hours of fatigue time. And the issue, though, that arose was not addressed by the statute. and that was what happens to the time that workers are spent waiting for their transportation from a train after their shift over to the next nearest platform. Is that waiting time on duty time that counts towards the 12 hours or not? The court applied in peri materia on this one, and it noted that the HSA provided exactly what to do with the actual time spent commuting to and from work. Deadhead time spent going away from the work site counted towards the 12 hours. Deadhead time spent traveling from the work site did not count. So when it came to the issue of waiting to be transported back and forth, SCOTUS looked at the other provisions in the statute, and it looked at provisions related to the travel time to and from, as well as time when train workers were able to take a break. And looking at the totality of that, the SCOTUS ruled that the time waiting for transportation to be taken away from the train was not, quote, on duty time, end quote. The court there said the distinction between transportation to a duty assignment and transportation from a duty assignment makes perfect sense given the statute's purpose of promoting train safety. Let's talk about a few other judicial doctrines which you will run into as you are administering the laws. A little bit about mootness and ripeness, both of which are very similar but will come into play and sometimes prevent a court from hearing a case. The first one is mootness. The theory behind that doctrine is that something happened that made the court's review of an issue moot or no longer necessary. This can happen when a controversy is resolved. Sometimes things get settled and resolved during litigation, therefore they're moot, and the courts don't move forward to issuing an opinion. Other times, the situation is that further legal proceedings just can't assist the parties. The court really cannot do anything to help the parties. It's not a court matter, therefore the case is moot. So some examples. These are actual examples from case law. A student is denied admission to law school. He or she brings a lawsuit and then is later admitted. That lawsuit is now moot. The court cannot do anything more to assist the parties in that case. The student has been admitted, so the case is moot and is dismissed. Sometimes you'll have a situation where a contract dispute is settled. Or the contract is complete, payment is made, for example. In that case, a lawsuit that was filed to challenge the terms of that contract, for example, may be moot and the case dismissed. In other situations, the law is changed in the middle of a dispute. So something may happen that a litigant is looking to get a law declared unconstitutional, and the legislature strikes the law or replaces it with something else. In that case, the underlying piece of litigation might be moot. There's also situations in the criminal law where someone is incarcerated and seeking release, and they're released from prison during the pendency of the lawsuit. The case then can become moot. There are, of course, exceptions to every rule, and mootness is no example. One exception is capable of repetition yet evading of review. Courts will still hear a matter if they find that it can be repeated and it is only evading the court's review because something has happened to moot the case. This is rare and it's an exceptional situation, but it does happen. And perhaps one of the most famous examples of this was Roe versus Wade. A woman who is no longer pregnant maybe does not have a claim any longer. Her question related to that pregnancy would be moot after she gives birth. But the courts are reluctant to dismiss cases that become moot in this manner and potentially then to allow the government or whoever was acting to continue with its same type of actions without having an opportunity for the court to review those. So in those types of situations, the court will reject a claim of mootness and say that even though the particular plaintiff is no longer pregnant in this case, that the case can still be heard because whatever arose that allowed her claim to go forward was capable of repetition and would only evade review if the doctrine of mootness was strictly enforced. Another example of that type of a exception to mootness is with short-term contracts. Many times there's a very short-term contract, the project is completed, the litigation then would become moot. But in cases where the court perceives that that type of those same basic fact patterns would continue to arise, the court will say that that's capable of repetition, yet evading review, and apply that. Ripeness is another judicial doctrine that the courts will use to dismiss cases or not get into a particular area. It's very closely related to mootness. Ripeness, though, is one that you as administrators are potentially more likely to see. You'll understand why as we work through a few examples. The United States Constitution, when it provided the powers to the judicial branch, required that the courts decide only actual cases and controversies. So that phrase about actual cases and controversies is where the doctrine of ripeness comes from. Basically, it prevents the courts from getting into a matter or entering a controversy before the other available remedies have been exhausted. So if there is something else that the litigants can or should do at an administrative level for our purposes, they need to do that before they can avail themselves of the courts. So when courts first get a case, they may engage or are oftentimes invited to engage in a ripeness analysis by the administrative branch. When they get such a claim, the courts will look to see if delayed judicial review will cause any hardship to the plaintiff, if judicial intervention is inappropriate because it might interfere with any further administrative action, or if further factual development is needed. If those items are found, or if any of those items are found, the court may well say that the case is not yet ripe for their review and dismiss it. So in the ripeness analysis, the courts are going to look for a real case or controversy. The courts are not inclined to wade into something and issue an advisory opinion or something based on a hypothetical situation, but they're looking for real cases and controversies. So a few examples. The court sees a challenge to the denial of a daycare license, but that challenge is filed before the completion of the agency's final review. That would be an example of a case that's not ripe. The agency still has administrative procedures that it can undertake. The plaintiffs are not harmed because they can and should continue to work through the administrative process, and then they can bring their case back later once it's ripe. Another example, a challenge to FDA regulations that require drug manufacturers to use labels showing the generic and proprietary drug names before it is enforced. This is an actual case that occurred. Drug manufacturers brought a challenge saying that they should not be required to list on their labels the generic drug name of essentially a competitor on their drug labeling. The court in this case held that the case was ripe, and the reason that it was ripe and ready to be heard, even though it had not yet been enforced, is because manufacturers would have to spend a considerable amount of money, time, and effort in order to recreate their labels and place generic drug names on their drug labels so that they were harmed, even though the matter was not enforced. So courts may find something is not ripe because potentially there would have to be some more steps before a review would be appropriate. But the courts are not going to require litigants to spend a lot of money or go through a lot of time and effort to be able to prove that there's damages before they raise something to the court. So sometimes courts will get into something that appears like it's not ripe, but they'll wade in because the litigants are at a point where the litigants have no other choice other than to bring the case or spend a lot of money in order to then bring the case. Another actual case was a challenge to a conditional authorization of a FERC. That's the Federal Energy Regulatory Commission. FERC assesses the needs for different kinds of energy projects and project alternatives, and made a conditional authorization to a plant. A challenge was raised. The court said that wasn't ripe. FERC had other types of steps and processes that it had to go through before the conditional authorization would become a final one, if it ever became a final one. So that case was dismissed as not being ripe. One of the most famous examples of a ripeness case comes out of the Ohio Forestry Association versus the Sierra Club. This is a SCOTUS case. The National Forest Management Act, NFMA, required the U.S. Forest Service to develop a plan for management of, in this case, the Wayne National Forest, which is in southeastern Ohio. That plan was required to set out logging goals and identify the areas that were appropriate for timber production, and do some other things to set the stage for logging production. Before any logging could take place, however, there was an administrative process that had to take place. There had to be an application, there had to be a notice and hearing, and some kind of an adjudicatory ruling by the government before logging could actually begin taking place. The Sierra Club, though, challenged the plan itself and alleged that there was an erroneous analysis taken that resulted in the plan favoring logging and clear-cutting too much. In this case, though, SCOTUS refused to weigh in. They dismissed the case, saying it wasn't ripe. The development plan related to Wayne National Forest just wasn't justiciable yet. The courts found that there had to be additional administrative steps taken before the case was ripe for them to review. The court held there that courts in general, SCOTUS and all courts, should not entangle themselves in disagreements that are still hypothetical or abstract over an administrative policy, but rather courts needed to step back and let the administrative branch do its work, especially in a case like this, where additional administrative process still had to take place before any clear cutting could be done. Let's take a turn now and look at one additional judicial doctrine for today, and that is the doctrine of standing. Standing essentially governs who can bring a case before the courts. The focus here is on who can bring the case and not on the cause of action. So this is a doctrine that you as administrators are likely to run into on numerous occasions. Generally, the doctrine serves as a restraint on the reach of the judiciary. It prevents the judicial branch from looking at certain cases where the plaintiff doesn't have standing to bring a case. But it's also used by the courts as a mechanism for allowing individuals a greater or lesser opportunity to challenge government. You'll find that standing is a threshold question which is often raised at the very beginning of a case and can be used to dismiss or remove a case from judicial scrutiny before even reaching the merits. The doctrine of standing has evolved over time, which, as we'll talk about here with the first case, you'll see is a very good thing that it's evolved. Probably the worst decision that SCOTUS has ever made, and the justices themselves will tell you that this was a dark day in Supreme Court history, was a case about standing. It was the Dred Scott case versus Sanford back in 1857. Dred Scott was a slave who was taken to the Free States by his owners and then sued for his freedom there. SCOTUS ruled that slaves were not citizens, thus did not have standing to bring actions in the courts. That ruling was effectively overturned 11 years later when the 14th Amendment was ratified, so the Dred Scott ruling is no longer good law. But it was very commonly known and even known today as a terrible decision. So from that platform, though, the courts have evolved their case law about standing. And today, the current test is as follows, and we'll talk about some cases to flesh out these principles. But when deciding if a party has standing to bring a case, the courts will look for three things. First is injury in fact. Was there some legally protected interest that was injured here? It needs to be a concrete, particularized interest. It cannot be something that's hypothetical, but rather the plaintiff needs to show that he or she has an injury, a true injury that's actual and imminent. Second prong to standing is a causal connection. There has to be some reasonable connection between the injury and the conduct complained of. The injury can't be the result of something that another party did, some party that's not even before the court. So in order to maintain standing and keep a case alive in the courts, the plaintiff will need to show that their injury was concrete and definitive, and that their injury was caused by something that the defendant, the other named party in the suit, did or didn't do. The third prong of standing is redressability. The plaintiff needs to be able to show that whatever they're asking for is something that the courts can give. So what their injury is needs to be able to be redressed by what the courts can order or do. And it has to be a likely redress, not something that's speculative or far-fetched. The watershed case on standing is Lujan Defenders of Wildlife, decided by SCOTUS in 1992. This is a case which really focuses on the first prong of the analysis. It sets out all three prongs, but the first prong is where the court's focus was in Lujan, and that is whether or not there was injury in fact. This case arose as a result of a provision in the Endangered Species Act, which required the Secretaries of the Interior and Commerce to consult before taking any action to make sure that there wasn't any jeopardy or harm to an endangered or threatened species as a result of what any department was going to do. The regulation enforcing that provision of the Endangered Species Act was initially read to be any kind of an action, whether overseas or not. Later on, that regulation was read to be more limited, and the Secretaries of Interior and Commerce read that to mean only actions which took place within the United States. So there was a more limited impact on this consultation requirement in 1992 or about that time when the Defenders of Wildlife brought their case. The defenders and other environmental groups sought to have that new regulation, the new interpretation limiting the requirement for consultation to actions within the United States to be declared invalid. They claimed that that lack of consultation, even on overseas programs, would increase the threat to endangered species and claimed that they were injured as a result of that increased threat to endangered species. The Supreme Court ruled that they did not have standing, though. They found that the environmental groups in that case could not show particularized harm. They could not show that there was any specific harm to either the group or its members, and that no member was able to establish any direct cause and effect. Although there was good evidence about the generalized harm to the entire ecosystem and the ripple effect of harms overseas, the Supreme Court held that that was not enough. The members of the environmental groups would need to show, in order to maintain their case, that there was a particularized direct harm to them. In another example of a standing case, and another one that focuses on injury in fact, you'll see that the Supreme Court used this particular situation as a mechanism for expanding standing. Unlike Lujan, where things were contracted, in this circumstance, the Supreme Court used standing to allow for more litigation. This case, Havens Realty versus Coleman, occurred when a housing advocacy group that was located in Richmond, Virginia, sent in two individuals, one white and one black, to an apartment complex that was not far outside of Richmond. The advocacy group had heard that the apartment complex, which was owned by Havens Realty, was treating applicants in a discriminatory fashion. So it sent in these two individuals called testers to see if they could rent. The testers were given different information on the same day about the availability of renters. There were more facts involved with this particular case, but we'll focus on this line for purposes of talking about standing. So the black tester was told that there were no apartments available. The white tester was told that there were several apartments available, and the advocacy group, using that information, sued. Havens moved to dismiss, though, and claimed that there was no standing. SCOTUS, though, found that the private parties did have standing in this case. The Fair Housing Act was the basis for their allegation of discriminatory practices, and SCOTUS found that the black tester had standing even though she had no intention of renting. So she didn't want to rent there. In fact, she had no intention of renting, even if they had offered her an apartment. So Havens Realty argued that she didn't have standing. She had no injury in fact. But SCOTUS disagreed with that argument and said Congress intended a broad application of the Fair Housing Act. That act prohibited discriminatory refusals to sell or rent and required that there be a bona fide offer to rent or purchase involved. So even though in this case the black tester had no intention of renting, there was still an actual injury in fact, in that there was not a bona fide offer given, and that she was refused the right to rent an apartment, whether she actually wanted to or not. The court went on, though, and found that the white tester also had standing and articulated the white tester's interest in living in a community that was integrated. And finally, the court found that the advocacy group had standing as well. And this was based on a drain on the resources of the advocacy group, which proved that it had to spend some resources to continually re-refer and re-counsel rental applicants when they were denied the ability to rent in one place and then had to look in another. Let's look at the second prong of standing, the causal relationship. There needs to be some kind of a relationship between the injury in fact and the defendant who's being sued. In this case, Simon versus Eastern Kentucky Welfare Rights Organization, this is also a SCOTUS case from 1976. Indigent people had been denied service at certain hospitals in Kentucky. They allege that the IRS policy of extending tax benefits to nonprofit hospitals, even though those hospitals didn't serve indigents, encouraged a continued denial of their services and ability to gain health care. SCOTUS ruled, though, that the plaintiffs did not have standing. In this case, the plaintiffs could not show that the tax policy, as opposed to any number of other factors, was the actual cause of their harm. So in order to meet this prong of the standing analysis, plaintiffs have to be able to trace their harm, in this case denial of service at a hospital, to the defendants, in this case the tax commissioner. A speculative theory of harm is not sufficient. The third prong of standing analysis is redressability. This is very closely related to the causal relationship, and in many earlier cases you'll see that causal relationship and redressability are actually discussed by the courts as a single element. But more recently, redressability has been examined separately by the courts. So in this case, from 1978, a mother sued under the Texas State Deadbeat Dad statute. What that statute basically said was that a person who was delinquent on their child support payments and refused to pay could be arrested and incarcerated for that refusal to pay as a criminal law matter. The mother, Linda R.S., claimed that the prosecutor in her jurisdiction in Texas was being discriminatory and failed to enforce the statute. SCOTUS ruled that she didn't have standing. The court here looked at the redressability standard. Certainly she was injured, but they could not find, and the mother could not articulate what it was that the court would do that would get her child support payments. Here, based on the case that she had laid out, even if the court had ruled in her favor and ordered greater enforcement, that there was little chance that the court's order would actually lead to the mother gaining child support. First of all, the court was very reluctant to order greater enforcement. They talked about the prosecuting attorney's discretionary authority to try certain cases or not, and was very reluctant to order any prosecuting attorney to take certain actions. But in addition to that, what they found was that even if they ordered the prosecutor to try these cases, even if they ordered the prosecutor to go fully through the entire process, that might result in jail time for the father of this plaintiff's child, but it still wouldn't result in child support. So the Supreme Court ruled at the end of the day that the mother did not have standing because there wasn't anything that the court could do that would definitively result in her obtaining the relief that she requested, which was monetary support for her child. There are a number of different exceptions and different ways of looking at and applying standing in various settings. But there are two that we'll talk about here in this class primarily because they impact administrators and will impact your work going forward. The first one is standing for trade association or other interest groups, or as you will likely run into them, constituent groups who may have an interest in something that you are doing or some program that you're carrying out. Associational or organizational standing allows a group to pursue the interest rights of its members. This is true even though the group itself doesn't have an injury in fact, but its members do. So the courts have determined that the group does have the ability or standing to assert the rights of its members. One of the leading case examples where this was acknowledged comes from NAACP versus Alabama in 1958. In that case, the state of Alabama sought the NAACP membership lists. It attempted to obtain the names and addresses of NAACP donors and members. And as you can imagine, in 1958, there was little positive intent behind the state's attempts to get that list. The NAACP fought to protect the list. Alabama argued that the group didn't have standing, that it could not protect personal constitutional interests of its members. SCOTUS, though, disagreed with the state. It held that the NAACP did have standing and that this was a good example of a time when a trade association or an interest group did and should have the ability to bring in action to protect its own members. Another exception is called the next friend standing. This allows someone without personal standing to assert the rights of another. You'll see this often in cases of a plaintiff or a defendant who's incompetent, somebody who is incapable of bringing suit, or someone who's incarcerated, for example. Sometimes the court will appoint a next friend, and you may have heard of this, especially here in Ohio, as a guardian ad litem. So those are people who don't have standing in their own right, but are permitted to bring standing on behalf of another. Let's talk about two cases that deal with this. The first case is Gilmore versus Utah, 1977. Gary Gilmore, you see pictured there, murdered two people. He was convicted, sentenced to death. He waived his appeals and asked to be executed. He was found to be competent. So although he was incarcerated, he was competent. His mother, though, filed an appeal on his behalf as a next friend. Her standing, though, was denied. The theory from the court there was that Gary Gilmore was competent and able to represent himself. There was no reason to allow someone to assert standing against his objections. Therefore, her standing was denied, and Gary Gilmore was eventually executed. Another case, this one goes the opposite direction, but you'll see why here in a minute. Hamdi versus Rumsfeld in 2004. Yasser Hamdi was a U.S. citizen. He was captured in a combat zone behind enemy lines in Afghanistan in 2001. He was declared an enemy combatant and held in the U.S. military prisons without a hearing for at least 3 years before his father found him and brought suit to enforce his due process rights. The father claimed that his son was in Afghanistan on a mission, on a humanitarian mission, and was not actually a combatant. But there was no opportunity for either he or his son to raise those rights because Hamdi was detained as an enemy combatant. He was not given any due process rights. SCOTUS held in that case that his father did have standing, that even though Hamdi was competent, he was denied the opportunity to defend himself because of his status as a enemy combatant and his inability to be able to bring a case as a result of that status. So in that case, the court held that the father did have rights as a next friend to bring the case on behalf of his son. So just as a quick recap, we focused primarily in this lecture on ways that the court gives deference to the administrative branch. The primary way that that happens is through a Chevron analysis, and this is a two-part application of a test set forth by the Supreme Court in the Chevron case. The first is, did the legislature address the particular issue or matter before the court? If not, or if the statute is ambiguous on the point, courts will give deference to an agency's reasonable interpretation. We talked about what constitutes reasonable and how you as administrators can act in a reasonable fashion in interpreting the statutes that apply to you and avoid being found to be arbitrary and capricious. We also talked about mootness and ripeness, which are two concepts which could help keep you out of court. The mootness and ripeness are very closely aligned, but as we learned today, they're not entirely the same. We also discussed statutory construction and some of the ways that the courts will look at the statutes, which you will also need to look at as administrators to determine whether or not the plain meaning or ambiguous meaning of a statute is properly applied. And finally, we talked about standing and a review of at least some of the factors that go into determining whether or not somebody can bring a suit against any other person, including against your agency or your administrative body. For next time, we're going to look a little bit more at judicial deference and focus on how the courts look at administrative rules and how an administrative rule is interpreted. The Chevron analysis applies to your ability to review a statute. The analysis that we're going to talk about next time will look more at your ability to draft, enforce, and interpret an administrative rule. Thank you.